Well, good morning, all. It's 15 minutes past 10. Mr. Paver, you were still cross-examining. Judge Makhubele, you are still giving evidence, and so I'm obliged to warn you that any further evidence you give is still evidence under oath. You are still under oath. You understand? Yes, Judge. Advocate Paver,
Thank
you may
you, President. I understand.
Yes, thank you.
Judge Makhubele, on the 15th of December of 2017, you had a meeting where the Siaya claims were settled.
Yes.
You remember that?
Yes.
Who was present at that meeting?
Me, Mr. Lindikaya Zide, and Mr. Madimpe Mkasho.
And you had invited Mr. Boertes to be present as well, is that not so?
Yes, Mr. Botes was supposed to be present with his attorneys.
And why did that not happen?
He said he was in Bloemfontein, if I recall well, and the matter that he was doing was taking long, and he was not able to come. There's a note that I think it's an extract from an email. I don't know how where it's. I just see it in the bundles, but it appears to be a message or an email from me. It's Annexure UBE 32. In the bundles, it's just in the middle of nowhere. When I testified last week, I mentioned this, that I don't know if you want me to read this, but I'm indicating that the intention was to have him and his attorneys, but due to your unavailability, we instructed him to engage your client. The last line I'm saying here, the correctness of the calculation of interest will be verified by PRASA Finance. So I don't know where this is extracted from, whether from my messages or emails, but it appears to be an annexure in the complainant's bundles.
Before we go any further, I just wanted to establish, and Mr. Matopo, was he not available either?
I don't know. The person that was communicating was Mr. Botes.
Now, Judge Makhubele, you told us that on that day you sat down with Mr. Mokhashwa and you went through each and every claim. Is that correct?
That's my evidence.
Yes. And how long did this process take?
Remember, it was not the first meeting, but my recording for this particular day, I've recorded 14 hours to 18 hours. That's according to my diary.
So at this meeting, as I understand it, you went through, what did you actually go through? Just let me just understand that. What did you actually go through? What documents did you go through?
All the reports that had been submitted at the time. Remember, Mokhashwa had submitted reports. Zide had collected the reports from employees and the consultations that he had done with the employees that I've already mentioned in my evidence in chief. So that was basically all the documents, all the information collected up to that day.
Now, during the process in which you got involved with it, did you approach any of the chief executives of the actual units who had entered into agreements with the with Siaya? Did you get them in?
If you listened to my evidence, I mentioned names and their positions.
well,
I can reiterate who they are and their positions. These are people who were heading those particular, some of the units. If I can get to it just now. And I mentioned in my evidence that some of these people had already testified. Some had received subpoenas to go and testify. There's, for example, a Mr. Baltek. We know about Baltek, that he was one of the people that testified and one of the people who had knowledge about one of the contracts or the claims. There's Mr. Litsane, is head of engineering at Rail. Mr. Thabo Mashia was at the relevant time SCM, and there's Mr. Kubuem, Mr. Thabo Mashia was a contract manager at Prasa Rail. Yes, so to answer your question, yes.
Those were the four persons that you
Did I
made a
count?
note of.
I don't know if you were counting, but I can. There's Kubue, there's Baltak, that's 2. There's Tabumashia, that's 3. There's Litsane Ratava, that's 4. This Litsane Ratava was at Prasa Rail. He head of engineering department. He joined in 2014, moved to tech. Apparently, this is the person that succeeded one Dr. Well, was found not to be a doctor. I think the surname is Mtimkulu. Yes, so those are the people.
Those were the people
Yes.
who you consulted with. Did you consult with the,
Mr. Zide, yes.
did you consult with the chief executives of the units with whom Siyaya had contracted?
If you can tell me who are those chief executives,
No, but
because I'm telling you that these are the people that had knowledge about these claims, and I have indicated to you their positions. So if it's a head of that unit, I don't know the correct title, whether they will say it's a chief executive. I've never heard of that title. To be honest with you.
well, I'm pleased that you, please, could
Executive,
we just cut to the chase now? We heard evidence from Martha and Goy
yes.
that the chief executives of the two respective bodies, the units who had contracted, was one Pete Sabola and one Kevin Munsami. Now, those names don't feature on the list of people you consulted with. Is that correct?
I don't know how they feature in the, because what we were following is people that had been either testified at the inquiry or were due to testify. So that name, those two names did not feature, and I have not heard anything about them. So I know nothing about them.
Well, Judge
These
Makhubele,
people that I have indicated to you and their positions and the knowledge that they shared, those are the people indicated either as having testified or as having received subpoenas.
well, I want to suggest to you that you were duty bound to consult with these people because that is what is required by the delegation of authority that you relied on.
If they were presented, yes. But I'm hearing about it for the first time here.
And I want to suggest to you hearing about the first time because you didn't act properly in the circumstances. Could you just allow me to finish my proposition and then you can respond? Judge Makhubele, you did not act properly. You had no authority in terms of the delegation of authority to do what you were doing. You were impinging upon the functions of the operational units within PRAZA. What do you say to that?
I denied that assertion. I assert that no one presented those two people you are talking about. They do not feature in the issues, those which were before the 417 inquiry, or even in the reports of that were before us that the attorney was presenting. So I deny in the strongest terms that that suggestion, Mr. Paver.
Now, it was never suggested to Mr. Mokhashwa when he testified that such a meeting of this magnitude, 4 hours, took place.
I don't know why it was not suggested, but I have my records. I consulted with my legal team, and as there's a document that I've already submitted before this tribunal that supports my contention that the attorney shared some information that needed to be followed up with regard to those the claim that was not settled. So I think at this point, with regard to what I may or may not have told my attorneys at this time, it's probably advisable to me to assert the principle of attorney-client privilege. Unless Malika was here, then he would be able to tell you what I told him or not told him. Thank you.
Judge Makhubele, we heard witnesses who said that you declined to give them access to the report of the Commissioner, Mr. Krieger. What is your response to that? I'll remind you, it was Martha Ngoyi, it was Fani Dingizwai who testified to that effect, and Mr. Mokhashwa who testified to that effect.
I've never had such a request, and in my evidence in chief, which I reiterate now, there has been no such request. I would have understood if maybe at the beginning someone would have said that, but not 6 years later, because there are communication channels. No one has ever written to me, email, SMS, or letter or anything requesting it. So I call upon you to provide that evidence that supports that I declined.
These witnesses testified before this
They
tribunal.
are word.
They said they wanted access to it. You refused to give them access. You cited collegiality as the reason why you were not going to give it to them.
My testimony before this commission or tribunal is that when Mr. Botes came with the first batch of documents, which is the commissioner's report, as well as some communication between him and Madimpe Mokhashwa. I was with Mr. Zide. Mr. Zide made copies in my presence to give to the legal unit. Whether he did give them or not, I do not know. And you will understand our lines of communication as we go on. If you don't ask me the question regarding that, I will provide evidence to this tribunal that indicates that anything that they wanted, I'm talking about the legal unit, they would obviously first go through Mr. Zide, and obviously if he doesn't respond to them, they would escalate it to me. There was an instance, it's on record, where apparently there's a communication in these bundles. I'll talk about it at the relevant time. That Ms. Ngoye apparently gave Mr. Zide to give to me, which did not reach me. So I have received no request. That's the short answer and the explanation. Thank you.
May I remind you that the reports that you say you read, which guided your decision-making, that in all of those reports, the persons making the reports, Kubuye for being one of them, Mr. Mokhashwa being another one, Mr. Dingizwaya being another one, they all say they were not given access to the reports upon which you placed reliance in making your decision.
I didn't finish. Okay, sorry, I didn't finish. I said I talked about the first batch. The second batch came by email, which was forwarded to me and to the CEO. There is a record, and if the CEO did not provide them, I did not receive any request. Up to now, this is 2024, I have not seen such a request. And with regard to Mr. Kubuwe's denial, I don't know where he denied that. I have not seen his denial. And I reiterate what I'm saying, that at the time, That is, even before this complaint was laid. If anyone had not received the report, to properly formulate this complaint against me, one would have wanted to have sight of that report. So it just escapes my mind how the complaint was formulated, because it's properly formulated that I relied on a report that apparently has a non-existent report. So if you say a report is non-existent, how do you know the contents to be able to formulate one of the charges that I'm facing? Anyway, that's for argument, but I just want you to think about it, that if the people accusing me have not had sight of these reports, how do they know that there are non-existing concessions? I suggest we leave it for argument.
So you made the decision to settle, is that not so?
I told you I was mandated to assist the CEO, who, according to the delegation of authority, has that power, financial limit. So, and by the way, you asked me to read that delegation, which I have read. And so your assertion that the board has no power to settle any claim is wrong. Your assertion that Ms. Ngoye has delegated powers, which I see her repeating in all affidavits, it's wrong. That delegation of power, of authority, it's a sort of a SEM policy document. And as I said to you yesterday, you must read it in its entirety. Authority you are delegated in writing. It takes into account your position, and then it says, you, Ms. Martha Ngoyi, as executive in this unit. That would be a letter to her from the chief executive. The power that I'm sub-delegating to you, your financial limit is so much. There's no such letter. And I do not understand why she keeps on saying she has that authority.
Sorry, the question is, did you or did you not settle the claims with CIA?
I was mandated to facilitate the consultations with the CEO, who had authority to settle those claims.
So would I be correct to say you did not settle the claims? I want to know the identity, the name of the person who settled the claims of CIA.
President, I'm saying that that was within the authority of the CEO, who I was mandated to work with, to investigate, to consult, and if we find that the claims can be settled, and then to settle those claims. So it was me and the CEO.
So you and the CEO
Yes,
decided to settle the claims.
yes.
Thank you.
But that evidence is at odds with what Mr. Makhashwa told this tribunal, which was also not challenged, that it was you who gave the instruction to settle, not Zide.
I've already told you that, and I want you to consider this. If you look at that evidence, he says he was just called to say and given an instruction, settle. I don't know if that can take 4 hours and at least 2-3 meetings prior to the final days. So I've already answered that, and as to how that evidence was not challenged, I've said I was under guidance of an attorney who I had employed. There's attorney-client privilege information. Unless Malika was here, then he would either waive that or allow me to tell the tribunal what we spoke about in our consultations. But for now, I think we should respect that.
Judge Makhubele, I want to refer you to volume 8, page 289.
Volume 8.
Volume 8, page 289. Do you have it before you, Judge Makhubele?
Yes, it's a
Well,
letter.
Well, it's a letter addressed to Ms. Martha Ngoyi,
Yes, from
the Group Executive,
Yes.
Legal, Risk and Compliance.
Yes,
It's Ray proposed meeting with the chairperson of the board to discuss the Siyaya matter. Do you see that?
yes.
Right. And if we turn over to the next page, you'll see that this was written by Insizwa Cromet Molepo. The date is the 8th of March, 2018. Do you see that?
Yes.
Now, you will remember the 8th of March was the day before Mr. Justice Holland Muter made orders relating to the awards that were made by Judge Brunt the previous month. You remember the sequence of events.
It appears to be the correct date, yes.
Now, I want to ask you to look at paragraph 1. Yesterday at 14:20, I met with the chairperson together with the company secretary as discussed. The purpose of the meeting with the chairperson of the board was to discuss the Siyaya matter. 2, the chairperson was willing to have a meeting with the AG CEO, that's the acting group chief executive officer, that's Mr. Maleko himself, is that correct? Correct?
Mr.
Malepo. The AG CEO at the time was Mr. Malepo. Is that not right?
That you are wrong. The acting CEO at the time, the claims were settled, was Mr. Zide, Lindikaya Zide.
I'm talking about the 8th of March.
Yes.
Now, this is not the...
As of these days, March, and remember that was the claims were settled in December. But as of March, the CEO was Mr. Mulepo, yes.
Yes, that is what I was putting to you.
I-
The company secretary at that stage was now Mr. Zide again. Is that not so?
Yes, he had reverted to his position.
And wanted to have a meeting with legal. That would be a reference to Ms. Ngoyi and Mr. Dingizwaya, the people who had knowledge of these cases. Is that right?
Are you still reading the paragraph, or you asking me a question?
What's your question? The reference there in this letter, did you understand it to mean The people from legal would be Martha Ngoyi and Fani Dingizwayo.
And the person, the attorney, the internal attorney who was actually dealing with the matter, Miss, forget her name, Miss, I think it's Mukotedi, if I'm not mistaken.
Yes, you're right,
Ma-
Mokotedi.
Miss Ngoye was just the unit head. Dingiswayo is the manager, litigation manager, but in terms of who was handling the matter, is one Miss Mukotedi.
So you didn't want Ms. Ngoye there?
I'm answering your question, sir. You asking me that the legal people will be these two. I'm saying that's not my understanding. When you talk about legal in the context of the summonses against PRASA that form the subject matter of this inquiry, you are talking about either Mr. Dingiswayo in his capacity as the manager of the attorney that was handling the matters, Ms. Mukotedi. So I'm not denying. I'm not saying I didn't want Ms. Ngoye to be there. Those are your words being put in my mouth.
Judge Makhubele, did you request Mr. Crommett Malepo to invite various people to a meeting?
I can't remember requesting him to invite people. What I know at this stage, there had already been arbitration orders that had been made, orders of court, and he, as CEO, was in the process of investigating the matter. So he wanted more information. This not just the beginning of his investigation. It's just part of it.
Judge Makhubele, did you have a meeting, as he said, at 14:20, as he said there, on the 8th of March?
I
Did you
cannot
have a
remember,
meeting with
sir.
him? Is that correct?
I cannot remember, sir. It could not have happened, but all my meetings I record them in this diary. I have a diary that each and every day when I went to Prasa, I will have to check my diary. If you allow me, every day I was at Prasa, I was writing why I was there and who I talked to about what kind of issues.
Well, can we just go back to paragraph 2 then? And I want to read the paragraph to you so you can digest it. The chairperson was willing to have a meeting with the AG CEO, company secretary, and legal, provided that she is advised whether her decision to settle the CIA matter is being reviewed or challenged. Now, that seems to imply that you were the one who made the decision to settle.
Well, as you say, implied, and I didn't write this letter. I don't know why he put it that way. When he joined Prasa, these claims had already been settled. So I don't know why he put that specific paragraph there, and I never instructed him to write this letter or to put things in the manner that he has.
But that accords with the evidence of Mr. Makhwasha's recollection that you were the one that instructed the settlement, nobody else.
which I've already denied, sir. I said on the final day, the 4-hour meeting, the three of us, and remember the, the delegation of authority says you also need to consult the external attorney if there's one, which is Mr. Muhashwa. That's the reason Muhasha was there, and he gave inputs, and some of the things were not in the report that he had already submitted initially. And as I indicated in the email that you have seen, with regard to one claim, he had information that initially was withheld from me. So I was not cross-examining him.
By your reply, I understand you to say that when it is suggested that you alone was involved in the settlement of the CIA claims, that is not correct. You shake your head.
No,
am I-
I'm nodding, President. I say you have put it well.
Yes. And it is your evidence that the claims were settled, you said earlier on, by you and Mr. Zide. That's the note I have. Is that correct?
Yes.
Yes. So if anyone suggests that you alone settled the matter involving Siaya's claim, that would not be correct.
You are, that's
That
my
is what you,
evidence.
yes. So paragraph 2, where it contains the word that whether her decision to settle the CIA matter being reviewed or challenged would contain an incorrect statement by saying that it involved only you.
Yes.
Yes, thank you. That is how I understood your evidence.
Mr. Botha testified that in the second week of November of 2017, you telephoned him. Do you remember that evidence, Judge Makhubele?
I remember his evidence.
And during the course of that telephone call, you asked him about whether he knew about the Siyaya matters. Did that happen?
Number one, I did not telephone him. There's already forensic.
No, you don't have to go on. You say when Mr. Botha. Sorry, you say when Mr. Botha said you telephoned him. That's not right. You did not telephone him.
President, I'm saying I did not telephone him.
Yes.
And I'm saying it's common cause that there's a forensic investigation report that clearly says he called me first. So, and that was put to him in this tribunal. So I don't know why it should become a controversy now.
Well, if you let the counsel finish his question, we will know what the controversy is. But right now, you simply asked to confirm a fact, if it is so or not so. So you say you did not telephone Mr.
I did
Botha.
not telephone him. He
Yes,
telephoned me.
that is all that's required for the
Yes.
moment.
Can I go to the second question? Because there were
Well,
two
I
questions.
didn't hear a second question. I want to hear what the second
The
question
second
is.
question was that I told him about CIA claims. So I denied that too.
Well, I didn't ask. Oh, did you hear somebody said you asked him about the CIA claims? Is that correct, Mr. Paver? Were you going to put that part of it to her?
I hadn't got to, what I did ask Judge Makhubele is whether she recalls that he said that she raised the question of Siyaya. Now,
It wasn't the
I think
question
that's
that
where Judge Makhubele
wasn't
is
the
correct.
question that Advocate Bottas phoned her to discuss the CIA matters.
I beg your pardon, Judge?
Was that not a question that you put to her?
I put to her that she,
That
according to Bottas,
according to Bottas, she phoned
him.
Bottas to
Bottas,
discuss
yes.
the CIA matters.
That is correct.
That was
That is
part
what
of
I
your
put,
question.
yes. But you, Judge Moshidi, you will remember that it was suggested in cross-examination to Mr. Bottas that in fact it was the other way around, that he'd phoned her. But now I want to deal with what was said during the conversation. According to Mr. Bottas, you asked him whether he was aware or involved in Siyaya or the Siyaya company's litigation. What is your comment on that evidence that he gave?
I deny that. I deny that. He raised the issue, going back and forth. He raised the issue. By that time, I had never in my life heard about CIA or seen any document about CIA.
Well, he then testified, and I quote from his evidence, Judge Makhubele immediately directed my attention to the fact that in her view there are certain pending matters which Prasa was involved in that should have been settled or sorted out long time ago. And what she indicated to me is the impression that she got was that some of the attorneys who acted on behalf of Prasa was exploited. That's how it's transcribed, Mr. President, and personnel within the legal department of Prasa undermined the authority of seniors, board members, including but not limited to you. And she further indicated to me that she preferred or regard being had to our long-established relationship to discuss and to ventilate these matters. And she, in so many words, indicated to me that she did not trust the attorneys acted on at the time on behalf of Prasa. And she also indicated to me that according to her, Prasa was captured by certain of its own employees and certain contractors. Do you remember that evidence that he gave?
I remember that evidence. I've heard it before.
So what is your comment on that?
I deny having told him anything like that. And as I say, by that time at Prasa, I had not had access to any document about CIA. So I deny that. And I don't know if the tribunal will allow me, because when I testified, the tribunal got impatient with me when I referred to documents. But I think this is important because I'm the one who is being investigated here, and the consequences are dire for me. Everything that Mr. Bote is saying, it's actually the opposite. He's actually the one who said it. If you look at our SMS communication, which is part of these records, he is the one, when we were conversing throughout, is the one who would be telling me PRASA employees are undermining you, you are a good person, your integrity is being challenged, you are actually, if you were to, you will allow me, you can allow me to refer to those SMSs. What he's saying is actually the one who was saying about PRASA employees. And there
Sorry,
are
do
two
I
exhibits.
understand? I just want to break it down so that we can understand what it is that you're telling us. When Mr. Botha gave evidence and he said you telephoned him, that is not correct. You did not telephone him.
Yes,
And when he says that you, the one that discussed the position of Siaya and what others were doing, that too is not correct because you knew nothing about the Siaya claims.
yes.
Yes, and I think that is all counsel really is getting at. Is there anything more, Mr. Paver?
No, that's
Yes.
precisely what I wanted to get some clarity on. And again, this is another instance where this
Before-
evidence was not challenged.
I don't know why, because what I'm saying, that is actually the one who says those things about PRASA employees is before this tribunal. There are two extracts. I think it's the State Capture Commission when they examined our devices. There are two reports. There are TAM1 and TAM2. It's extraction from our telephone records. When you go there, you will see clearly who was following who and everything that was saying about PRASA employees.
Well, you continued to communicate with Mr. Botha, isn't that so? You even invited him to attend a settlement meeting, which led to the settlement of these claims.
I didn't hear the first part of your statement.
That you communicated with Advocate Botha until the matters were settled.
President, I don't know if it really assists me or the tribunal if I'm not allowed to submit documents to prove that what he is saying is not correct, what Botha was communicating. The forensic, in the face of the forensic investigation report, I don't know why would the prosecution still persist with their assertion. I really don't know. I really don't know because for me, that should be acknowledged. And if there are any issues that they want to raise with me, they should then raise them in the context of available evidence. But if I'm not allowed to present documentary evidence, I don't know, and I don't like denying. Just to say in a vacuum, I deny when I know there's a document somewhere that supports me. Thank you.
Sorry, Chair, could I set the record straight here? We don't have prosecution in this proceeding. I try to define our role here and our titles in the beginning. We are a tribunal set up by the JSC. And in fact, there is no precedent here. Former JP Joppy is the chairperson of the tribunal. Me and the lady next to him are members of the tribunal, as set out in our terms of reference. Counsel cross-examining you now is from the side of the evidence leader. I think we need to get this term straight. We're about to get to the end of this inquiry, but proper reference must be made to the parties involved here. I understand there's a difference between prosecutor and evidence leader appointed for these purposes. Don't we agree on that?
I apologize, Judge Mushidi, maybe for me to call them, since we started here, we have been calling them pro forma prosecutors, and maybe that's the reason they treat me like they are prosecutors. But I apologize, they are evidence leaders.
Well, they're the official evidence leader before a tribunal here. That's simple.
Thank you. Can I just say, I understand what you are here to do because there are terms of reference. You are collecting evidence, facts, and but the adversity that's displayed by the evidence leaders against me, because if there's a document and the purpose of this tribunal is to collect evidence, why don't they allow or recognize that document? Because at the end of the day, you are here to collect facts, collect a document. It doesn't assist to keep on asking me that Advocate Bottas says you called him because there's already a report of a forensic investigator. It doesn't help to keep on asking me that I say PRASA employees undermine me, my authority, when there's from the extraction of our devices, it shows our communication. And I'm saying this because I was constrained when I was giving my evidence, and when we further delayed by all these common cause issues, I'm the one who's being prejudiced.
Well, maybe, Chairperson, we should leave that and go back to the question posed for the sake of progress.
Well, if I may just then suggest, for the sake of progress, as pointed out, if you say that there is other evidence that supports you, and that evidence is to be found in the record of an inquiry, you may certainly say so. But what counsel is trying to get is, how do we deal with Mr. Bottas's evidence when he says the opposite? Are you saying then what Mr. Bottas said is not true, and you are supported by other evidence that was held at an inquiry? You don't have to refer to it. You simply have to state what your position is. Because if we keep on going forward and backwards to other evidence, we'll be here for a very long time. That just simply is the way to deal with it. Thank you. You were about to put to Judge Makhubele what Mr. Bottas has said further, I believe.
Mr. President, I did actually put it, and then that elicited a response from Judge Makhubele about how it was the other way around, and that Bottas was how I just want to come back to your evidence that you gave in this tribunal. You seem to suggest that Bottas had abused your trust that you had placed in him. Is that correct? Did I understand that correctly?
I will answer that question first, but can I simply just say to the President, I agree with what you are saying, and my answer to the two propositions put to me is that The answer is no, and I refer firstly to the report of the forensic investigator. His name is Rudolph, I forgot the surname. Number two, with regard to what Botes says about my attitude against PRASA employees, that you will find in its extraction reports by the investigators of our WhatsApps, our SMSs. So that's the support for my denial. And now coming to your recent question about my evidence, you are saying I testified that Botes abused me, or my trust, abused my trust. Well, I think the word I used was it's what I said in my complaint against him. One paragraph reads something like that, but in this tribunal, it was suggested to me by the tribunal members, I cannot remember who, that that's when the word abused was used. And I think we had a discussion about that. But the word that I used is trust. But the tribunal came with the word of abuse.
Well, there was a point at which you say you distanced yourself from Boetes, is that right?
That's correct.
When was that?
Beginning of January, when 2018, when I was told that the finance department was not paying the claims, and I then decided to step back to say, if there are allegations, let them be investigated. If the legal unit say they are the ones who should have done this, let me no longer get involved. And from the extraction report of our communication with Botes, if I'm not mistaken, there's an email, an SMS or WhatsApp, the date, I believe it's 13 January 2018, where I say to him, firstly, he must stop contacting me or making inquiries about CIR claims or payment. And when he then requested, I don't think it's on the same day, later days, as I kept on saying I no longer want to get involved. And I told him at some point I deleted my WhatsApp. That also appears from our communication, because I was tired about this, what I deemed constant messaging inquiries. And he asked for the telephone number of the CEO, because by then there was a new CEO, Mr. Mulepo. I gave him the telephone number of Mr. Mulepo, and from there is the one who was making inquiries with Mr. Mulepo. Thank you.
We heard evidence, Judge Makhubele, that the PRASA was being pressed to pay. That was even before the awards were made. Do you remember that evidence?
If you can tell me whose evidence that is first, maybe I will try to jog my mind.
Let's speak in general terms. You had instructed, together with Mr. Zide, according to you, on the 15th of December, that there should be a settlement of the claims. You remember that? On the
Yes,
15th of December.
yes.
On the 18th of December, Mr. Matopo writes and tells Mr. Mokhashwa that he was not acting according to the instructions which you had given. Isn't that right? You remember that? Mr. Matopo's letter to Mokhashwa on the 18th of December, 2017. You remember that?
Yes.
And the reason why Mr. Matopo could write a letter to that effect is because you had given to the other side, you had given a copy of your instructions to Mr. Mokhashwa, to them. Isn't that right?
I don't remember that evidence, but what I seem to recall is the evidence of Mr. Mukhashwa with regard to, I think it's interest, how Matopo attorneys came to know about what was in that settlement letter, which I have already explained, that there's this loose document which I can't place that where it comes from, but it's from me to Botes where, and the reason why that letter was given to him. And what I remember is Mukhashwa considered that it was his error not to include interest because those were his instructions. And I may add, because he was there. So he considered it was taken up with him in this tribunal, and I think also at the State Capture Commission, that in the first place, those were his instructions. Lawful or unlawful, but those were his instructions, it was his error.
Well, you see, on page 82 of volume 19 is the document you're referring to. And this is from you to Mr. Boertes that you've told us already. I forward the letter to Praza with instructions to inquire from Mokhashwa if he received this and to forward the same as ASAP as soon as possible. Our instructions were transparent, hence I forwarded the copy to you. Now, this is a reference to sending the letter containing the instructions to Mokhashwa, isn't that right?
The document that I've already read here comes from, it's part of what you are reading, because
Yes.
this one appears to be just the tail end of that email.
Sorry, it's the beginning of that message.
It's a tail end because it has it only has 4 lines and then regards Nana. So what you are reading appears to be the top part of this document.
Yes. Now,
So you say it's where? What page is that?
it's page 82 of volume 19. But you've got it in front of you. You read from
I
it.
don't have the full text. I've already said that I just found this loose paper, and just to confirm that why Botes was given that letter, that in the first instance, he and his team were supposed to be there. And by the way, I think I didn't respond to your suggestion that I invited Botes. We invited Botes. The 3 of us, we invited Botes, and I don't think it was me who communicated with him. So when I submitted this document, it was to show that there was nothing secret about it.
Well, did you send the agreement or the settlement instructions to the people in the legal department? Did
I
you?
think, can I just complete that? I think there's a report, there's an email somewhere. I can't offhand think where to locate it, where Botes wrote and requested a copy of that when Mukhashwa sent to Matopo. Remember, there was that official communication between Mukhashwa and Matopo that he should also copy him. Anything that he sends to Matopo, he should be copied. So to answer your recent question whether I sent the document to legal, it was in my I've already explained to you how information and documents would went about, but I believe Mr. Zide did. I don't know. I cannot remember. I had no direct communication with legal.
Judge Jaffe, my leaders asked if we could just take the adjournment now.
Yes, very well. We will adjourn for 15 minutes then, Mr. Paver. Thank you. Paver. Judge Makhubele, you are still under oath. Yes.
Thank you, President.
Now, there was a problem, as we gathered from the evidence about payment. That's following the settlement that you and Zide had agreed to. Do you remember that?
I said that
Yes.
just now.
Yes. Now, Mr. Maleka placed it on record, and I refer to the evidence of Martha Ngoyi, and I'll read it to you. Thank you very much, Chair. Chair, a few housekeeping matters. I've taken instructions from Judge Makhubele, that would be you. And I can put it to Ms. Ngoyi that Judge Makhubele has not given any instruction to anyone in PRAZA to pay Siyaya directly or through its attorneys that amounts indicated in the settlement documentation we have looked at. You instructed Mr. Maleka to put that
Yes.
to Ms. Ngoyi. She was testifying at the time.
Yes.
Yes.
Can we just have the reference, please?
It's evidence given by Martha Ngoyi, and it's recorded. It's on page 340
Of the merged transcript.
of the merged transcript, Mr. President. Right. But now, in volume 11A at page 33, there was an email sent by you on the 21st of December, the Thursday, the 21st of December, 2017. It's addressed to Madimpe Mukhashwa. It's copied to Lindikaya Zide, and the subject is Ray Arbitration for Siyaya / PRAZA. It reads as follows: Dear Madimpe, thank you for the update. Mr. Zide, please attend to finalize the matter with respect to the payment part. Regards, Chairperson. Now, can you explain how these two propositions are consistent with each other?
Thank you, Mr. Paver. I've already explained, unless if you want to see if my explanations at various stages is consistent or not. One of the issues when I gave evidence in chief, I addressed that issue that I instructed Zide to pay. And there was a wide media reports that Makhubele instructed Zida to pay. And when I testified, I placed that email in context. I referred to it specifically that when you read it, it doesn't say, please pay. And I said, we all know Zide is not in finance. When when I sent that email and say he must attend to payment, there are procedures, we all know. Zide, as the CEO or acting CEO or company secretary, whatever position he was in then, he would know what to do. They prepare a memo, it goes through various stages until it reaches finances. So I never instructed anyone who is capable of effecting payment to pay. The purpose of the settlement was to pay at the end of the day. It's like when you cook, you intend to cook, to eat the food. So at the end, after the settlement was done, everything was done, obviously the next stage is to present it to whoever has authority to pay, and Zide would know where to take it. So it's like when you cook to eat. So it was settled to pay, and following the channels of payment until it reaches finance. I've never instructed finance to effect the payment. So that's the answer that I gave when I gave my evidence in chief. And that's why my counsel would have put to Ms. Ngoye that I never instructed anyone to pay CI.
Well, you instructed Mr. Zide to finalize payment.
It's not an
That's an
instruction.
instruction.
It's not an instruction.
Well, then I think the question is, what did you expect Mr. Zide to do with the communication that you are now sending to him?
I expected Zide to follow the payment processes, which apparently you would have prepared some memo to finance, who would have required some documentation and some confirmation as to which budget the payment would be coming from. So it's a process, Chairperson. It's a process.
Would I then be correct if I put it this way? You were telling Mr. Zide, according to you, for him not to pay, but to put the process in motion that would allow payment. Is that what you say?
That's correct.
Thank you.
Now, payment wasn't made. And by January, you were still in contact with Mr. Botha in late January. Is that correct?
I've been in contact with Mr. Botha until March of 2018. It depends on what we were talking about. So if you can put something to me, what you are talking about, but he never stopped contacting me, and at some stage I would respond. At some stage I would ignore him. But our last communication was in March of 2018.
Yes, well, you provided the tribunal with some papers there, when we were last here, and they included text messages between yourself and Mr. Botha. And there's one text message, the 24th of January 2018, and it is from you at 11 o'clock, and it reads as follows. I'll read it into the record. Dear Francois, my quietness is caused by shock and disgust at the open defiance displayed by the finance lady. There's been rumors, there was rumors, but let's just deal with that first sentence. Why were you so disgusted and shocked?
Because they were talking about me. The rumors.
Why were you so disgusted and shocked by the open defiance
Because
of
they
the
were because
finance
of the
lady?
rumors that were coming through to after Zide apparently had submitted those whatever documents he needed to submit, and then Zide told me that she has told him she is not going to pay, which she actually refused to entertain his, I don't know whether to call it presentation or instruction to, it's called an instruction to pay, but it's not instruction in the sense that you say you are sending someone around. So, and he told me that she defied that. So I was I was quiet for some time, and I think that's when I had told Botes that I no longer want to talk to him, and he should be communicating, the lawyers should be communicating about the matter.
Well, it didn't stop there. You continued to communicate with him. On February 8th, dear Nana, Judge Brunt made 4 awards on Wednesday, 7 February. Madimpe was present and undertook to, the printing, Mr. President, to include Prasa Accord or inform, I don't know. I managed to speak to Mr. Cromet Malepo Tate during the afternoon. And do you remember this SMS from Mr. Boertes? This is now the 8th of February.
I don't have it before me, but when you, and you know, if you present an SMS, and because they are on record, you can just direct me where to get it. But I remember that SMS where he was giving me a report after they went to Judge Brand, and further reported to me that he has spoken to Cromet Mulepo, and if I'm not mistaken, that SMS goes on to say Cromet has told him that Prasa should not waste money. Is that the SMS?
Well, it says, Mr. Cromet Maleta, he spoke to him during the afternoon, and his view is that we shouldn't incur any further legal costs herein, and that we should provide Prasa an opportunity to consider the awards and to effect payment. The last thing I want to do is to create further disputes or animosity. Matopo instructed me to prepare applications as envisaged in Section 331(1) of the Arbitration Act. I'm reluctant to do so if I make a turn page, in the event that payment is imminent. Please advise. Kind regards, Francois Boertes. This is now the 8th of February that he's still communicating with you.
But I never denied communicating with him. I've just said I communicated with Botes up until March of 2018. It depends on what we were talking about, but I had already informed him that he should not involve me. And if you care to read my response to him, I simply said, thank you for the update.
Yeah.
Is that not what I said to you?
Yeah.
So I don't know why you would say, my evidence is I spoke to him throughout, but I was no longer entertaining him because I had already told him that I'm no longer involved. You should call that Cromet Mulepo you are talking about was the CEO then. So Botes, that's why I say if you read all the emails, Botes was now running around Prasa. Cromet Mulepo is the new CEO. Botes went to him. I don't know what their discussion was, but as that SMS says, Cromet promised him that Prasa was going to pay.
But then, as you say, you continued to speak to him up till March, including informing him that Bowman's had no mandate whatsoever to act on behalf of Prasa in their opposition to the applications to make the awards orders of court. You sent messages to him.
He sent my testimony, and again, that's in Annex T TAM 1 or 2 of the state capture records, extraction of our SMSs. He sent me a message, and I testified here last week, to ask whether the PRASA board, I think that's how we put it, maybe you should not read selectively for context, because I don't have those chain of SMSs, but it was a long conversation. He sent me a message. I didn't send him a message to ask whether the PRASA board had made a decision to oppose the application that was apparently going to be had that morning or the next day, I don't know. And my response to him, maybe we should follow sequence. Off head, I can tell you my response to him before that line that you have just read was to say, nothing has been brought to my attention. As you know, I'm no longer involved in this matter. I've memorized some of these SMSs, but the gist of it was I told him nothing has been brought to my attention. As you know, I'm no longer involved in this matter. I no longer have interest. I'm preparing for my exit from PRASA, and as we are speaking, I'm on my way to Cape Town. That's the day that I was going to Cape Town. That was my reaction to his SMS.
Did you send him an email or any correspondence indicating
No,
what you're telling us now?
no, no, President, I did not. And that's where my allegation that Bottas forged a letter comes from, because I never received a letter inquiring about the authority of Bowmans or any communication from the attorneys. It was this SMS from Bottas, and which, when you read in context, as I'm saying, this was my response to him, and he responded, I responded, and then I said, I don't know who appointed Bowmans. As far as I know, I don't know if they are in the SACA panel. You remember at that stage there was a resistance by the legal unit to use SACA panel. I said, I don't know if from SACA panel, because the board has already decided that only SACA panel attorneys should be utilized. So if they are not from a SACA panel, then in my view, there would be no authority. And unbeknown to me, Bottas now wrote a letter, or his attorney wrote a letter to Bowmans, pretending as though there has been a formal request to the board and a formal response by SMS, and then those SMS communication were then pasted in that letter.
Now, that answer that you now gave, how does that relate to the question Mr. Paver put to you?
Pardon?
Well, Mr. Paver put a question to you, and you gave an answer, and I just want to know what's the relationship between the answer you gave and the question Paver asked. Would you like to put the question again, Mr. Paver?
Well, I was inquiring or just confirming that you were still communicating with Bottas in March of 2018, at about the time that the orders were being sought by SIAIA to make the awards an order of court.
And I'm saying it maybe for the, I don't know, 10th time today sitting here, that I communicated with Botes right until March. So I've never denied communicating with him. It depends on what we were talking about. So, and I did say our last communication was on those dates early in March, when just before those applications.
Now, on page 299 of volume 8, you've got volume 8 in front of you,
Volume 8, page
299.
299. Oh, yes. I have it.
On that is the letter from Matopo to Bowman's. And in paragraph 2, it's stated, your purported notice of intention to oppose the 4 applications are irregular and you do not have any mandate from the board of the Passenger Rail Agency of South Africa, PRASA, to represent it in these applications and to oppose the applications on behalf of PRASA. Advocate Nana Makhubele, SC, is the acting chairperson of PRASA's board. After we received your purported notice of intention to oppose the 4 applications, we requested Advocate Nana Makhubele, SC, to indicate whether or not the board of PRASA has decided to oppose the 4 applications. Advocate Nana Makhubele, SC's response was as follows, and I quote, those attorneys have no authority. PRASA legal panel has been suspended since 1st December 2017. We are using SACA panel. I know they couldn't have been appointed through that panel. Only those who had instructions already continue. I've just asked Mr. Zide. He says the decision was taken by Martha Ngoyi and the current AG CEO. Did you send a message like that to Mr. Boertes?
Mr. Paver, I don't know. I've already responded. And your repeated questions, I don't know what it intended for, but I've already answered. I've already given the context, and maybe if you can allow me, this is a request that I'm making to go to the entire email trail, because this is just an extract of maybe the last 2 lines of a long SMS. Can I go to the
Before you do that, as I understand the question, you are referred to in correspondence between Mr. Matopo and Bowman's. And Mr. Matopo seemed to suggest to Bowman's that coming from you, Bowman's have no instructions to defend the matter as far as you knew. Now, either that is so or it isn't so. Did you tell what is actually going on is, did you tell Mr. Matopo that Bowman's had no instructions?
No, I never spoke to Mr. Matopo in any by email, SMS, in person. So
No, if you haven't spoken to him, then he must be making that up. There seems to be no answer.
Because I see you are looking towards the evidence leader.
Oh.
I'm saying this is what I say. I don't know what would be the right words, because this letter says, we, meaning Matopo attorneys, have requested Advocate Nana Makhubele, which is me, to indicate whether or not the board of PRASA has. So my answer is, I did not get a request from Matopo attorneys.
Yes, that's
So
how.
this part of the letter is not correct.
Well, that is all they wanted to know.
Yes, so I never communicated with Matopo.
Yes, thank you.
Judge Makhubele, I want to repeat my question because I didn't suggest you'd written this to Matopo. I asked you a very straight, direct question. This quote that I read to you, is this a message which you received from Botha's? That's what I ask you, and I simply want a response which is either yes or no.
And I said I responded. I diverted to answer the chairperson's question. There's no need for you to get angry or impatient with me. I have an obligation to answer any interjecting question from any member of the tribunal.
Yes, you are quite correct, Judge Makhubele. So can you please then deal with the question that counsel has now put to you? And I will remind him, Mr. Paver, please just turn down the tone of it.
Yes, well, the question is, did you receive a message to this effect, a quote that I've quoted to you from Mr. Botha's?
Point of correction, there's no receipt here. Maybe if your question was, did you send anything close to this quote to anyone? And my answer would be yes, to Botha's.
The further quotation on that page. Morning AG CEO. As discussed just now, I'm at Parliament Office of the Ministry for an urgent meeting with the DM. I'll be available tomorrow to discuss the issues 1 to 10. I must state, however, it has already come to my attention that you authorized legal services to oppose the matter under 6 and furthermore to use the services of the suspended legal panel. This matter involves me directly, and I would have expected a courtesy briefing before decisions were taken. I will seek legal opinion on the matter after I have sight of the grounds of opposition. On the issue of firm that's in the suspended panel, I believe it's further evidence of disobedience of board resolutions. I will advise the board accordingly. Regards, Nana. Now, did you send such a message to Mr. Botha?
I did not send this message to Mr. Botha's.
How would Matopo have got this message?
I was answering your question whether the message in quotation is sent to Botha's or not. And my answer is it's not to Botha's. It's I sent this looks like a message, part of a communication between me and the acting group CEO.
Well, how would it have got to the notice of Mr. Matopo to include it?
I have no idea, I have no idea. I wish you can ask him. That's why I say I never communicated with Matopo how he got hold of this. Maybe if you can ask him.
What else is there?
Just to clarify, you had no direct communication with Mr. Matopo, is that correct?
That's correct,
Yes.
Chairperson.
So if Mr. Matopo says that this is what you allegedly said, then what you are implying that that must be something that somebody else would have said to Mr. Matopo. And that is the one part. The next part, to that you say no, you never spoke to Mr. Matopo. The next part is then if you didn't say it to Mr. Matopo, did you in fact say it to anybody else? And if so, to whom?
It appears to be a communication between me and the then acting group CEO.
In your message that we read, the first one, you say the PRASA legal panel had been suspended since the 1st of December. Was that correct?
That's a fact.
The 1st of December 2017.
That's a fact, Mr. Paver.
Beg your pardon? Please?
It's a fact,
It's a fact.
yes.
But you were in charge of a chairperson of an incorporate board. Your decision had no binding effect.
I understand your client, I don't know if I must call them complainant your client, but the complainant has filed an application at the Western Cape High Court about the status of the interim board, and I haven't had anything. I'm not aware that of any ruling with regard to those issues, and I have never had an opportunity to answer as to the correction of the PRASA board. To my knowledge, the only outstanding member in terms of the legislation was the National Treasury representative. And as to whether decisions taken when one member in terms of legislation is not present are valid or not, I believe those are issues that maybe the complainant wanted the court to rule on. I have no knowledge if there has been any ruling.
I don't think the question deals with whether the board was curated or not. The question is going to Martha Ngoyi's evidence that it was a decision taken by a board that was not properly curated and one that a instruction given by you that they should not deal with the PRASA matters. Am I correct, Mr. Paver?
Yes, Peter.
Yes.
The problem when I answer his questions, he puts in something that also requires me to answer, because I did answer that, yeah, the PRASA panel it's a fact that the PRASA panel was suspended on 1 December 2017. And then he says, that's the time when the board didn't correct. So that too requires my comment. So maybe my answer should have been I'm not aware of that the board didn't correct, or I don't know how to answer it, but
No, you have. According to you, the only outstanding member that wasn't on the board was the treasurer, I believe.
yes,
Yes.
So it didn't pose a problem to you that the Legal Succession Act wasn't being adhered to?
there was a request for National Treasury to send a representative, and we were always kept informed about what's happening between the ministers, the communication, and that member was subsequently he subsequently joined the board in early February. I have a date here. There's actually a letter that's in one of the documents that I was printing yesterday. So we all know if it's either when he gets there, he is briefed about what happens. If he doesn't agree, obviously he will not ratify the decisions or anything like that. But that's why I'm saying the legal status. A decision becomes a decision until it's reviewed and set aside for whatever reasons. So it's not for me or you sitting here to say the decisions were invalid.
Well, it's not as easy as that because we have a minute of the meeting, not a minute of the meeting, we've got the transcribed record of that meeting, your first major board meeting on the 1st of October of 1st of December 2017. And Mr. Zide drew your attention as the chairperson to the fact that the board was incorrect and the problems that would arise. And Ms. Yvonne Page also weighed in on the subject of the incorrect nature of the board. But in spite of that, you continued to make decisions which could not be valid. And in fact, that was endorsed by the ENS opinion, which you rejected.
I don't know why you are dragging the ENS opinion in your question, because I'm ready to answer your first question, but how it relates to ENS opinion, maybe I will require you to, if it's linked, yes, I'm bound to answer. But if it's not linked to correction of the board, you are about to show me something. Let me wait before I answer it.
Well, perhaps if I can assist, let's break the question down. There is a board meeting on the 1st of December 2017. Am I correct? So we know what we're talking about.
Yes,
Yes.
that was a special board meeting.
And at that board meeting, one of the items that came up was the suspension of the PRASA's legal department. That's correct too, isn't it?
Yes,
Then, as Mr. Paver read out from the minutes, that it was drawn to the attention of those present that such a decision would not be of legal effect, as I understand it, because for reasons that we've already discussed over here, that two persons drew the board's attention to it. And my understanding from part of the question is that that what they said was not adhered to or given any serious attention because the suspension went ahead. Would I be correct?
I haven't seen the transcript. I saw it, but I haven't read it. If you can, I will have to read it.
No. The question is, you were present at that
I
meeting.
was present, but
Yes,
I can't remember.
you can't remember.
Yes, I was present. I can't remember because I have not seen the transcript.
Yes, thank you.
Well, may I remind you, and it's on page 805 of volume 6 before the tribunal. Mr. Zide, sorry, Chair.
Can I go there before you
I
read?
think you've got it in hard copy, Judge.
Page, volume?
6.
I don't have volume 6.
Page 805, Judge.
Yes, I do.
Mr. Zide is quoted as saying, sorry, Chair, I just want to raise a thing on the issue of a quorum. We have received this issue of the AG, and I don't know whether it will have an effect on the meetings, that unless and until there is an appointment of the Treasury representative, the board is not properly constituted. But insofar as the issues of quorum, I thought I should just raise the issue so that it is considered. So that was raised by Mr. Zide directly with the board.
Yes, in the meeting, yes.
And then later on page 820,
No, Mr. Paver, don't skip because I think it's necessary for you to read my response. It comes exactly after Zide raises it. Why would you want to hide my response?
yes, fair enough. What is your response?
My response, yes. Yes, it's true. Zide, his last, it says, I thought I should just raise the issue so that it's considered, and then chairperson, which would have been me. Maybe we need to discuss it as an item. Where can we put it? And then a board member responds, under quorum chair. So you wanted to skip all this to wherever it suits you.
No, Judge Makhubele, that's not the intention. The intention was to draw the tribunal's attention to this particular document, because it is one of the documents which the tribunal has had access to. And then I also want to refer you to page 820, where Miss Page, she was Yvonne Page, she was the CFO, was she not? She also raised the subject on page 820. Now, the AG says we have a board, so he can't sign now because we have a board and it's not duly constituted. Now, to make matters worse, PFMA says 2 months after you've submitted the financials, you get your audit report, which means 9 December, which is next week Sunday, they're going to give us an audit report. Now, she also implies there that the board is not properly constituted. So what did you resolve to do, Judge Makhubele, in the light of what was being raised by these two very senior officials at PRAZA?
I've already dealt with the response on ZD to say, let's put this matter on the agenda. And then the other board members supported my suggestion, so we didn't ignore it. So I'm trying to look. It's quite a lengthy transcript. One would have to look at whether indeed it was discussed, it was put in this agenda, because there's a suggestion that we should, by me, we should discuss it as an item. Where can we put it? And then someone says under quorum chair. So let's kick that one of Zide out. Then you say Miss Page says what she is saying, and I don't know whether she's referring to the previous board that didn't correct, or she's referring to us. So I will with all humility, Mr. Paver, can I just read this transcript to understand these issues?
Let's go to page 822.
I've requested to read
Just
the
wanted-
transcript.
To read it, what is it that you want to suggest to Judge Makhubele? That the board wasn't properly curated, so
It was
how
not
could they
properly curate.
curate?
Yes.
And so the decision to
Suspend
the legal team
Mr.
wasn't a
Chairman,
proper
the
decision.
legal panel.
Sorry, the legal panel.
Not the legal team, the
Yeah,
legal panel. Yes.
was not
of no
properly.
effect.
Yes, that is what you ultimately want to. Well, then I think you should simply just put it to her from your understanding of what is in the record.
Thank you. I just want to suggest to you that the decisions which you made to suspend the legal panel were of no force and effect. They were invalid because you were the chairperson of a board that was not properly constituted in terms of the Legal Succession Act to make any decision which was binding.
It's not an automatic invalidity, as I said. Someone will have to bring an application to set aside that decision, and based on whatever reasons, then the decision will be set aside or upheld. And I've already said it's not for you and me sitting here to say it's invalid, but as far as the board was concerned, that it had made a valid decision.
Sorry, but if I may intervene, don't we know, don't we know now that the matter went to court in the Cape High Court, and the minister was then ordered to appoint a board properly? I think that was a ruling given in the Western Cape High Court not long ago. Am I correct? That is, the minister was ordered to appoint a board properly. And what had happened before was set aside. Is that not so?
Thank you for that thought, Judge Mushidi. You could be referring to a different matter. The recent decision of the Western Cape High Court, I think it's a year or two ago, where the minister had appointed some administrator. That decision was set aside. But this particular court application I'm talking about, it's the one where the complainant was challenging the appointment of the interim board, and I think also, I don't know if there was a specific challenge to the resolution or just a general mention that the decisions would be invalid. And that's the one that I say I'm not aware if there has been a judgment, and maybe someone can help me out. Then I can read that judgment and and make whatever concessions that I need to make.
Well, all what I wanted to know is whether that which I ask you is not linked with a question posed to you in cross-examination now about the invalidity of decisions taken by your board during December 2017. Don't you think it's linked?
Judge Mushid, there was a court application. All I'm saying is I'm not aware of a judgment, but I am aware of a judgment of a matter that came later, where I think it's the administrator was one, Mr. Mpondo. That judgment I know of, but the one about our board, I have not seen it. I have not seen it, and the complainant is listening to me. The evidence leaders can hear me, so let them help us out. And
Well, it reminds me to ask another question in connection with this. During your tenure as interim chairperson of PRASA, from October, I think, 2017, right up to your last meeting somewhere in, was it November?
March,
March. Did it ever occur to you as the chairperson, senior counsel, about to become a judge now, that the decisions that you were taking at the board chaired by you may be invalid? I mean, they're all relying on you with your experience and expertise, legal qualifications. And here you are chairing those meetings. But did it ever occur to you that the decisions that you took, especially on the 1st of December 2017, could be invalid, unlawful, and susceptible to be set aside and reviewed by a court of law later on?
Judge Mushid, and as I say,
Sorry, I can't hear you.
and as I say, I never disregarded the matter or acted recklessly. As you can see from this transcript, I'm putting the matter on the agenda. So I want to read to see how we handled the matter. So before I answer that, so it's not a complete disregard as Mr. Paver would like to put it. And it's after our board was taken to court in this application that I don't know what happened to it. Some of I remember we got to a point where, because of that application, we were no longer considering certain matters that require decisions. And I remember in one of the meetings that I had with JP, and this is the meeting that was attended by the DJP. I'm sorry for referring to this, but I want to answer your question whether I was reckless or not, or I was aware and took precautions. We did discuss, I did say that if there has been any discussion about PRASA and the controversies at PRASA with my leaders, that would have been the meeting, because they wanted to know from me if any of the litigation in our court has anything to do with any decision that my board has taken, and my answer, I reassured them that no. And they also wanted to know whether there are any other controversial decisions other than the one that had already been published about the CIA claims. And I assured them that there were no other decisions that we took, because we became consciously aware that there is a challenge that's going on at the Western Cape High Court. And for the record, and for that matter, our board did not consider, make decisions on any tenders that were submitted to us. So we became cautious and about it.
Well, you asked me to wait, you'll answer my question later. I shall wait and I shall hand
Yes,
you over.
I want to know what we did, because I say here,
If you give me time to talk and not interrupt,
sorry.
I'll wait for you to answer my question at your convenience. But I'll hand you over to Mr. Paver to continue.
I'm sorry, before you continue, can I have a bit of time to read this transcript? Because I don't want us to adjourn today without me giving you an answer as to what happened to this agenda item.
Well, procedure-wise, you're in the hands of the cross-examiner now. I think, Mr. Paver, you continue.
Mashidi. Now, I want to draw your attention to the fact that on the 28th of November, you directed correspondence to Mr. Zide. You will remember the correspondence which arose out of the reports you'd received. And I just want to remind you that in paragraph 12, you said the reports from you, Ms. Ngoy, and the officials indicated in paragraph 9 must reach me on or before 12 o'clock on Friday, 30 November 2017, to enable me to report to the Board of Control on 1 December 2017. Do you remember that?
Yes,
And that related to the CIA matter, is that right?
yes,
Did you report to the board?
yes, I did.
And so that should appear from the transcript. Because you had this special board meeting you told us about. That was 1st of December. Now, nowhere in that transcript is there any mention made of the Siyaya litigation which you wanted reports on.
I testified in this tribunal that there were two kinds of meetings. The one in committee, and then there would be the open board meeting that would be have a transcript like this one. I also testified that when I left, I think it was in the context of you asking me why I still communicated with Prasa, and I said, what was anticipated? And you will agree with me, except for one board minute that I have signed, there are no minutes of any committee or any board because of the errors that needed to be corrected so that I can sign off the minutes that I needed to sign off and other committee chairs needed to. So I, without even having read this transcript, I can assure you that you will not see that report in this transcript. Maybe in the minute, which I don't have them. On my last day, I think I went back. There was an instruction. It's in one of the papers from me to the secretariat that she must finalize preparing all board minutes in committee and open meetings so that I can sign off, and all committee chairs must sign off. But then it never happened because when I left, everything, I no longer had access to Prasa minutes. So I have not signed off any minute except the one of 1 October 27, no,
If I may,
27, is it 27 October? 30 October, yes.
no, I think, and I speak subject to correction, if I followed the question. On the 28th of November, you wanted a report from legal at PRASA relating to the CIA matters. That's the correspondence that was read to you. Isn't that correct?
That's what he asked me.
Yes.
And it
No.
appears from the memo.
Yeah. Now, and you wanted it before the 1st of December. And the question then is, if you wanted matters relating to CIA for the meeting of the 1st of December, then why doesn't it appear that it was raised at that meeting, which you had on the 1st of December? And you say, well, that was a special meeting. Now, that then begs the question, was it ever raised at a board meeting of PRASA, the matters relating to CIA, as far as you can remember?
My response, Chair, was there are two types of meetings, if I can maybe stop using this in committee and other words. There are two types of meeting. So in any meeting, there would be only board members meeting. And then there would be a meeting that would be attended by everybody that you would see maybe in the attendance register. So what I'm saying is what we had decided was that we will have minutes of each of this meeting. What we discuss in the meeting where there's only board members, and then what would be the general board meeting, like the one where they've attached this transcript. So the minutes would then be signed off to include things that were discussed by board members only. And my further response was that I never got to sign off any minute except for one of our very first meeting, but the rest I have not signed. So I have not seen if it has been reported or not.
So, do you understand your evidence? It's not in the transcript because this was some other meeting entirely.
I don't know who you asked for this transcript. Maybe you should have, I don't know who you asked. And I don't know whether you've asked for the minutes and what was given to you, but I'm saying there is a meeting where that only involves board members, because this, as you can imagine, is a meeting that has everyone in it.
Well,
So I don't
perhaps
know
I
where you
can,
got
perhaps
this.
I can assist. As you're sitting there now, Judge Makhubele, do you recall any meeting at PRASA, and as you were the chair, during the time that you were the chair, of a meeting of the board, whether it's the full board or a truncated board, where the matter of Siaya was discussed? Whether it was minuted or not is a separate question. Do you recall any meeting where it was discussed?
Chairperson, I do. This meeting of 1 December, yes. And if you recall, the memorandum that is reading, it's amended. In the first memorandum, I had not included the reporting on a specific date. So I amended the memorandum. I don't know which memorandum you are reading. There's the original memorandum, then there's the amended one with paragraph 12 that says, I want to report to the board. So it was reported.
Do I understand from that answer that you now gave that on the 1st of December, at a meeting of the PRASA board, the matters relating to CIA were discussed, and what was discussed is in a minute that is not part of the minute read to you by counsel?
Yes.
Now, can I ask you then, was the CIA matter minuted at all?
Chairperson, I say I have not received, I was supposed to receive all minutes of the board. For both what you just said, truncated board, and then the entire with the executives, I was supposed to receive those minutes and sign them off. But as at the time when I left, they had not been provided to me.
No, that was not my question. My question was simply that at the truncated meeting, as I now understand, the CIA matter was discussed. And perhaps my next question would then be, where are the minutes of that discussion? And the answer would be, you didn't receive it.
Yes.
Yes. Thank you.
Now, you attended a meeting with the Minister of Transport on the 12th of March 2018, at which it was resolved that you would prepare a report to the Minister. Is that not so?
Yes.
And you didn't do it.
I've explained in my evidence in chief that when I went back to the board and a decision was taken that the board, it will report. We must compile a response. And unfortunately, that was my last day at BRASA, but I did attend consultations. The board mandated one board member called Professor Maluleke to collate all the information about CIA matter. And also the board resolved to seek a legal opinion because the issue was the powers that Ms. Ngoye claims to have, that she has authority to do. She's the only one who has this authority and no one else. So the board wanted an opinion on that, and Mr. Maluleke was to arrange consultation with council. When I left, we attended consultation with the attorneys. I can't remember who was the attorneys appointed, but I think I remember there was a preliminary opinion or view to appoint Advocate Malika, and I think in our first meeting, it was just still discussion whether he will take the matter or not. When I left, I was not called again by the board to give inputs on to compile the report to the minister. And I've heard that the minister did not receive, obviously not mine, but the board's report.
But you were the one that had all the particulars as to how these claims were settled. The board wasn't privy to it.
Are you putting a statement or a question to me?
Sorry, I put it as a question. Is it not so then?
You are wrong.
We
you
have
are
heard,
wrong.
no,
Who-
sorry,
you are
Judge, can I
wrong.
just
Who-
finish my proposition?
Yes.
We have heard no evidence whatsoever that anybody else other than you, together with Mr. Zidi, crafted a settlement agreement.
What's your question?
I think the question is this. As you and Mr. Zwidi had settled the matter with CIA, the minister wanted the report on that particular issue. And from your answer, I understand that he received no report on that issue. And reference to other people doing the report doesn't quite help to answer the question, because nobody else other than you and Mr. Zwedi was involved in the settlement. That is, as I understand, what the question is all about. Mr. Paver?
Precisely.
Yes.
I reject your proposition. It has no basis. My evidence, if you say nobody, it would mean you would have called people to say nobody except me and Zide know about this. And I say what in my evidence in chief, the board knew, and I kept everybody informed as I was working with the CEO, and I've just testified now that from the report that says, from the report that you read into record, 28 November, paragraph 12, I say I want to report to the board. And I'm saying I reported to the board. So I reject your suggestion that nobody but me and Zidane knew about it. So and when you look at the letter that I've written after my first, not even going to my letter, email communication from Mr. Cromet Mulepo, who was CEO by March, after the meeting of with the minister, you will realize that everybody knew about Siaya, and the only request was that let's collate all the information to write a report to the minister. Thank you.
Well, as to your knowledge, do you know whether anybody, whether you, Mr. Zwede, or anybody else who may have been on the board, who may have been involved in the CIA matter, reported as to how this matter with CIA became settled?
I'm not aware if anyone reported to the minister, chairperson. I'm not aware.
Would this be an appropriate time to take the adjournment?
Sorry, just before we adjourn, Judge Makhubele, and this involves you too. I had a request from the OCJ that we wanted to adjourn at about 1:30. Is that correct? Well, it's 1:05 now, and if this is a convenient stage, we will then adjourn. I understand but I just want to confirm that when we will reconvene again, would that be the 11th of March? And a venue, I suppose, would be forwarded to us, or we will be told by then where we will meet. If you want to discuss this, Mr. Paver,
Chairperson,
Advocate
Can
Harrison.
we just stand down briefly and
I
then
was
I
going-
can confer with my leader on the way?
Yes, you certainly
We are
may.
pretty close to the end of our crossing.
Yeah, no, well, if you're pretty close, then we can carry on until about 1:30.
Yeah, well, I just want to
Yes.
get some final instructions.
Do you want me to adjourn, or?
Maybe just maybe adjourn briefly and we'll
Yeah.
call you immediately we are ready.
Yes, please do.
Thank you.
Well, we can stand adjourned for Mr. thank you, Mr. Paver.
Thank you, Chairperson, for the time allowed. Judge Makhubele, I want you to refer to volume 1 at page 145, volume 1. Yes, volume 1, please. 145. It's headed UB19.
Yeah.
145.
Sorry. That's the, the decision of the ombudsman.
Volume 1, it's been provided to you,
Then
page
we have-
145.
I don't know why my electronic copies.
Now, please look at the hard copy, Judge. Do you have it in front of you? Right.
Yes, volume 1, page 145.
Now, if you look at page 145, the bottom half, it appears that Mr. Kulili George had sent what appears to be a message by Gmail. Now, Mr. Kulili George was a member of the board, wasn't
Yes.
he? And this appeared to relate to Siyangena. Because your response do you see that? Your response on the top, March the 22nd, 2018. Do you see that? The subject, review application Siyangena Technologies stroke Praza TA. Do you see that? I read it to you. XG, that's obviously a reference to Mr. George. You are confusing matters, and I reiterate what I stated at the BOC meeting on Friday, that you seem not to follow discussions. Putting it on paper complicated and implicated some people's lives even further. I'm now beginning to wonder who are the people I've been serving on this interim board with for the past 5 months. I remember sitting with those who were to travel to Cape Town to attend the last POCT and venting my frustrations on them that most of you have no interest in on most issues I raised, either by memos or in closed session before board meetings. I choose to remain silent. If any one of you want to join Martha and Goy and Fani Dingiswaya, go ahead. I agree, we must meet. Writing an email and mix facts and matters is a bad start. Regards, Tan, T-A-N. Now, what gave rise to this?
I think he did respond to my email that he was mixing matters.
No, but I asked you a question, Judge Makhubele.
I can't remember, but I seem to remember that you see the caption here says review application Siyangena. So I can't remember the background. I'll have to look at other emails. But if you read his his contribution on whatever was being discussed, he was completely not following what was being discussed. He was confusing Siaya and Siangena matters.
But now, what did it matter to you? You had resigned on the 16th of March 2018, and here you were almost berating him and your other board members.
I've already testified here that even though I had left, we were compiling reports. One of the report that was to go to the minister, and I think I attended a consultation with council. 16 was a Friday. I think the next Tuesday, I attended a consultation with attorneys and council and some board members. So I was still, I used the word tying loose ends that required me to, and at this stage I was still waiting for board minutes, as I say, so that I can sign off everything. So I didn't think there's anything wrong to, and besides, the email I think was directed to me. Let's see,
Well, before
I can't
you-
see the
no.
original email, but I think whatever was being discussed was directed to me and all board members. So I had to respond.
So when you say at the last line in your email, I agree we must meet, who are the we you're referring to?
The board members.
Now, council seems to suggest why you want to meet with the board members after the 22nd of March when you have already resigned as the chairman of the board around the 16th of March. Whether
That-
you can recall why you want to meet them or not is another matter.
And I say, Chairperson, there was it's unfortunate that the email is read in isolation. It doesn't show where it starts, but if I look at it probably was sparked by an email from Fani Dingiswayo. I could be wrong, but when I look at the documents, I haven't had time to look at this, but there's something that both of us were responding to in the review applications Yangena Technologies for us. There's an email. I don't know what sparked this, but whatever it was, it's something that required us to meet.
Judge Makhubele, if you look at page 147, the original email came from Fani Dingiswaya on the 21st of March 2018. It was addressed to Lindy Kaya Zide and to Cromet Malepo. And Martha Ngoyi was also copied in this.
That's why I'm saying it's probably sparked by this email from Mr. Dingiswayo, but I'm not sure because I have not read this email now. but it could be. I'm looking at my own records now, but it could be because when you look at the date of the email from Mr. Dingiswayo, it's 21 March. But it can't be because this one is copied to all board members.
Now, if you look at page 146, Natalie Skeepers, she was also a board member. Is that right? And she then raises the governance issue in the absence of a chairperson. Do you see that in the middle? 22nd of March, 2018, 10 hours 53.
Yes, and which will be the reason why I agreed to meet because Chairperson, this one board member says they cannot respond on governance decision making in the absence of a chairperson. And then she say she's giving a report about other things. Correct me if I'm wrong. Now we are stuck. The problem that I want to, you'll pardon me, Chairperson and members of the tribunal, is the evidence leaders have not laid a foundation to contextualize these documents they are referring to. And they simply putting them to me. I mean, someone should testify about what he is trying to establish from this document.
Well, we're trying to establish it from you, Judge Makhubele, because you were...
I'm still talking. No matter how much you disrespect me, allow me to
Yes,
address
now
the
just
tribunal.
please answer, give your answer as you intended to.
Yes, I say I cannot answer because there's no context. Now I'm trying to scratch my head as to why were we talking about this thing. I mean, he needs to call a witness to come and give context to this email.
Yes, I'd remind you that Fani Dingiswayo gave evidence relating this, just to remind you. But let's go to the last paragraph of Mr. George's message, just before the words of kind regards. He says, with 6 members remaining in the board of 11 members, are we not still cooperating to make lawful decisions, to defend the interests of the business, notwithstanding the pending High Court case in the Western Cape challenging the legality of the appointment of the board? Legal must guide us on this, otherwise we are exposed individually and collectively to the risk of financial consequences should we elect not to act or react into this matter. But you told Mr. George that he was confused.
I'm saying I don't know what we were all responding to. So, because when you read the last paragraph that you are reading, it's completely different from what you suggest may have sparked this conversation. So you'll have to give context.
I just want to establish from you. Was the reason for the closed board meeting, you described to the tribunal that there was a discussion with a closed board meeting in relation to the CIO matters. Was that to exclude legal from taking part in it? The legal department?
That's not the reason. A closed one is not attended by executives. And that's what I've already said, that the closed one, it's the board members. And then there's open one, which would be attended by executives and from all units. And you heard the evidence of Martha that she does not attend board meetings. I don't know why. It's not my decision that she doesn't attend even open board meetings.
Thank you, Mr. Chairman. I've concluded the questions I wish to put to Judge Makhubele.
Yes, thank you. Judge Makhubele, before you finish your or conclude your evidence, is there anything else that you wish to say in regard to the matters before this tribunal? Or anything arising out of questions that were put to you?
I wanted to call one witness.
You wanted to call one witness?
I want to call one witness.
And who is that?
There's a clerk at the High Court in Pretoria, Miss Komani. I will ask the state attorney to arrange her. It's a very short evidence. It won't even take.
No, you don't have to warn us. You want to call a witness.
Yes.
And the date that I've given that we can reconvene, and we will just have to decide this now in the light of you wanting to call Mr. Komani, is that correct?
Yes.
As to when we can meet again. A date had been arranged for us to meet at the Office of the Chief Justice just to sort out the record in this matter. So can we just stand down for a short while, and if you can discuss the witness that you want to call with the OCJ, and they will let me know what's it all about, and then we will come back and we will take the adjournment. And how we proceed will depend upon what they tell us. So can we stand down for a short while, and then we will adjourn for the day. We stand down. Judge Makhubele, I understand that you require a witness, as you informed me just before the adjournment. That's correct, isn't it?
That's correct,
Yes,
Chairperson.
and the OCJ will need to know the details of that witness by next week, Wednesday, which is the end of this month. So arrangements could be made in time to have the witness available when we meet again. You understand that?
I understand, Chairperson, we have already spoken to Ms. Mondani.
Yeah.
Ms. Mubengi will let her know by Tuesday.
Well, that's good.
She will first talk to this person if they can come willingly. If not, she will let OCJ know by Tuesday.
Yes. We will then stand adjourned and we will meet again, hopefully to complete whatever else is outstanding on the 11th of March. That would give everybody more than enough time to get themselves ready. And if I may indicate, there is a housekeeping matter we'll have to attend to, and that is to sort out the record in this matter, because as it is clear already that the record is a bit all over the show, and we would have to sort out a record. We will then make arrangements for the filing of heads, and we will then make arrangements as to whether we hear the parties or not. Speaking for myself, I would like to hear oral argument, and then we will adjourn for the ruling of this tribunal. Hopefully, it can all be done by by April this year. I hope it doesn't take any longer than that. You understand, Judge Makhubele?
I understand,
Yes.
Chairperson, and as I indicated, we're still pursuing my counsel to come and represent me with oral submissions.
Yeah, that's fine. That's no problem. Is there anything else, Advocate Harrison, that you wish to add?
Thank you, Chair. May I just ask, are we only adjourning for the 11th of March or
No.
are we adjourning for the whole week?
As I understand it, we would have to be available that whole week. I don't think we will take the whole week, but we will need at least, after the witness, a day or two to sort out the records, and everybody can apply their minds to it, because as to what would be the official record of these proceedings. And I can tell you now that the feeling of the tribunal is that we would require written argument. We have a very lengthy record, so we will require a written argument. And we will then hear the parties after that, and then the tribunal will give its findings or directions, if I may say so. There being no other business, we then stand adjourned till the 11th of March. The Office of the Chief Justice will let the parties know as to where we will be convening on that date. Thank you.